Welcome, everyone. Thanks so much for being here. I'm sure some more folks will join us as we get started. My name is Molly Curran-Rolls. I'm Executive Director of the ACLU of Maine. As you all know, we're gathering during an incredibly heavy week here in Maine, as ICE violence has now culminated in another extrajudicial killing, this time in Biddeford on Monday. We want to be clear and unequivocal that this killing happened because of a failure of law. As the ACLU has argued for over 25 years, our federal laws have not provided clear and enforceable restrictions on the Department of Homeland Security at any point in its history, nor have they ensured accountability when people lose their liberty or even their lives. This is particularly true during this administration. While we're here tonight to talk primarily about the Supreme Court term, and we'll be focused on that, we wanted to applaud Governor Mills' statement today that ICE's violence must end. She said, quote, ICE's violence must end before more gunshots shatter another windshield, steal another person's life, and fracture the freedom of all who seek peace, and that ICE needs to be fundamentally reformed, and if not, then it's time to abolish it. We wholeheartedly agree. We've just launched a petition to help raise awareness among elected officials and the public about three new important laws, the ICE outlaws, that go into effect on July 29th. We need your help to ensure enforcement of the ICE outlaws. They're ICE out of policing, ICE out of our homes, and ICE out of our schools and state healthcare. These laws will protect our communities and ensure that local officials and resources are not used to support dangerous and chaotic federal immigration enforcement operations. You can learn more and sign the petition at aclumaine.org/iceout. We're so grateful to the many people, including many of you, working to provide support and mutual aid to the bereaved family in Biddeford and to thousands of Maine people across the state who feel unsafe and are living in fear right now. No one can be free when they're afraid. When we stand up to protest, when we make our voices heard in the public sphere in any number of ways, we can help create safety and freedom for those around us. As always, you can find information about how to know your rights when protesting, how to approach protesting at our website, also at aclumaine.org. So thank you again for joining us and for your ongoing support of our work. It's my pleasure to introduce the folks who'll be speaking tonight. Carol Garvin, ACLU of Maine's Legal Director. We'll be joined by Zach Hayden, our Policy and Strategy Director and Chief Counsel, and Aaron Rosenblum, our Engagement Director. Their discussion of the Supreme Court's term will include several high-profile cases involving immigration, including our own case defending birthright citizenship, which we won last month, as well as so many other critical issues for our state and for our country. Again, thank you so much for being here, and I'm pleased to turn things over to Carol.
Great. Thank you, Molly, and thank you everyone for being here in what has been a really tough week in Maine, but I think that has made it all the more important that we are all thinking and talking about our civil rights and about immigrants' rights. So I'm going to start with a quick intro about the Supreme Court and how it does its work. And I'm going to talk a little bit about the shadow docket. And then Zach and I will have a discussion back and forth about some of the really most important and most far-reaching merits cases of the term that just ended in the end of June, and how those cases will impact and continue to impact all of our civil rights. So first, just a little bit about how the Supreme Court does its job. So the Supreme Court of the United States is the ultimate authority on the interpretation of federal law and the federal Constitution. So it actually isn't the final word on state law or our Maine state constitution. That is the province of our own law court, our state Supreme Court, which has a really strong, independent ability to interpret our Maine constitutional provisions. And that is all the more important in recent years as we see some of our federal constitutional protections getting cut back. Those rulings on the state constitution are not ever reviewed by the Supreme Court, with limited exceptions. But the Supreme Court still is the ultimate arbiter on all matters of federal law, and so has a huge amount of influence. And so how does it do its job? So it is not just hearing every case that, filters up to the court. It also isn't hearing some kind of, random sample of cases or representative cases. It is very, very selectively choosing which cases it wants to review. Usually the court gets petitions for review, sometimes called writs of certiorari, in about 8,000 cases. it only hears maybe 60 to 70 of those cases on the merits. So under 1% of all the cases that it could review are ones that it's actively deciding it wants to take up. And so that's really important when we're thinking about the spectrum of the cases the court hears. It's a really selective group of cases that this court has already decided it's interested in the arguments raised by. And this most recent term in the court, we saw yet again a really unusual court in a couple of ways. In particular, we saw a court that has a 6-3 conservative majority. So that's a significant majority. That means it's a court that is taking really big swings and not taking kind of a gradual or incrementalist approach. And it is a court that is making these swift moves to overturn precedents, overturn or reinterpret how the Constitution has been interpreted for many decades often, and choose to take cases, sometimes really reaching out to take cases that are raising what, even a few years ago would have been considered kind of fringe arguments. So that is a different way of operating than the court had for a number of years until just recently. So we are going to talk most of today about the big merits docket. That's the big written opinions, the big oral arguments that you're usually hearing about in the news. But there is, and I want to just spend a couple minutes on an entirely separate docket, which is often called the shadow docket. And that is really different than the merits docket, but really important because this is a docket where the court is hearing expedited cases. There's usually no oral argument. It's making unsigned opinions, and often there's no reasoning at all. So it'll be just a one-page, sometimes a two-page opinion. And so there's really no guidance for the lower courts. There's also no transparency about how they reach those decisions. And this shadow docket, it existed since the 1970s, but for a long time, it was really just for death penalty cases and a way to get those cases up to the court very quickly so that executions that were wrongful could be stayed on an emergency basis, could be stopped. But it has transformed in the last several years. So especially in the past year, we've just seen this huge increase in how often the federal government is asking the court to issue a shadow docket order, this kind of expedited order, blocking the reasoned opinion of a lower court. And usually what the Trump administration is doing is making an emergency request saying that they should win on the emergency docket instead of the lower court's ruling, which had found that the federal government had overstepped, had abused its power. And in the last year, we've already seen 30 emergency requests from the Trump administration. And just for comparison, in the entire 17 years from 2001 to 2017, there were only 8 federal government requests for emergency docket decisions. And we've also seen just this incredible increase in how often the court is granting those emergency requests from the federal government. So in the past year, the court has sided with the federal government, again, just in these shadow docket decisions, 80% of the time. So that shadow docket is always lurking in the background. That is continuing. It doesn't end with the sort of normal end of the term in June. So just wanted to flag that as we're going to be focusing more on the merits docket, that is a really important way law is getting made these days. But yeah, I'm going to turn away from the shadow docket into the merits decisions. That is going to be the focus. And Zach and I will go back and forth about some of the huge cases that the court decided in the term that just ended on June 30th. So I'm going to start with the birthright citizenship case. This case was the very last decision of the term issued on June 30th. And it is about the citizenship clause of the 14th Amendment. And I'm just going to read that in full because it's pretty clear. So it says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. That's the language. This was the constitutional amendment that was ratified in 1868, so just after the Civil War. And it was clearly, ratified to ensure citizenship to everyone born on U.S. soil, regardless of their parents' race or color, ancestry, or immigration status. The 14th Amendment essentially guarantees that we don't have a permanent underclass of non-citizens over multiple generations in our country. So unlike many other countries in the US, if you're born on our soil, you are a citizen. On Inauguration Day last year, President Trump tried to change that. So he issued an executive order that very first day that sought to deny birthright citizenship to huge swaths of children, essentially all babies who are born to undocumented parents or to parents with temporary status, like a work visa or a student visa. That same day, the inauguration day, our organization, the ACLU of Maine, along with ACLU National and a number of other partners, we were in court suing the federal government just hours after the inauguration to challenge that executive order. And very quickly, our district court judge, who was a Republican appointed judge, quickly ruled in our favor. And the judge ruled, look, this executive order violates the very clear language of the 14th Amendment, and it violates longstanding immigration law as well. And the
Yeah,
court,
just to
yeah, go
sorry,
ahead.
just to build on that, Carol and I
Yeah.
were actually sitting in the courthouse, in the courtroom at the council table when that happened. And those of you who have been in federal court maybe know, there's an argument, and then the judge usually says, okay, I'm going to think about this. I'll have a ruling for you in a few weeks or a few months. Or even I'll just go back and think about it for a little bit and talk with my clerks. There was none of that here. The judge issued this decision right from the bench as soon as the argument was over. He understood how strong our arguments were and how weak the government's arguments were.
Yeah, it was an incredible day. Unfortunately, that was not the end of the situation. So then that our case continued, but also the Supreme Court last term stepped in on this issue by way of another case called CASA. And this was another case about birthright citizenship. And here the court limited district court's ability, lower court's ability to issue a nationwide relief. So essentially that meant that no court could issue an order barring this executive order from taking effect for all babies. It left huge numbers of children unprotected. So we reacted again by that same day, the same day that the court issued that order, filing a case. This was a new case, and this time it was a class action. And this is the case of Barber versus Trump, the case that eventually gets to the Supreme Court. So here we challenged the same executive order, made the same legal arguments, but this time we sought to represent not just our plaintiffs, but all babies across the country who would be deprived of citizenship under the order. And again, the court acted incredibly quickly. Less than 2 weeks later, it granted this class certification and granted the injunction as to all babies affected in the nation. And then the case made its way up in a very expedited fashion, and the Supreme Court granted review just in our case. So there were a number of cases percolating, but it chose to review just the Barber versus Trump case. And our legal director for the National ACLU, Cecilia Wong, argued the case on April 1st. People may have heard President Trump actually attended that argument. Just for the first part, just for where the government's arguments were being made, then he left. But it was the first time ever for a sitting president to actually attend a Supreme Court argument. And several people from the ACLU of Maine were able to go down to Washington, D.C. for that argument. And the question before the court was simply, does President Trump's executive order limiting birthright citizenship violate the 14th Amendment? And does it violate the longstanding immigration statute?
Yeah, and it was a fascinating experience for Carol and I. We've never been involved in a Supreme Court case up this close, never mind a landmark constitutional Supreme Court case. One of the things that was fascinating, I mean, the preparation that goes into this, every possible argument, every second of everything is sort of planned out and tested. There was a lot of discussion about how should Cecilia Wong, our national legal director, how should she start her argument? What's the first thing that she should say? Should she tell story? Should she talk about the history of this clause? And what she ultimately decided, as those of you who listen to the argument know, is to start with the exact words that Carol started, this with, that everybody knows, everybody learns. If you're born in this country, you're a citizen. So, Carol, how did the court respond to that?
Yeah, so spoiler alert, but the court did decide that the executive order from President Trump violates the 14th Amendment. So that was a relief for millions of babies who could have lost citizenship. It was a 5-4 decision on that constitutional question, so incredibly close. But It was a victory on the constitutional question. And the court essentially said, look, we have had a tradition for hundreds of years. In fact, going back to English common law, this principle of what's called jus soli, or right of the soil. And there was the Dred Scott decision, which was a huge aberration, which was a sharp departure from that tradition, essentially saying that no Black people, whether slave or free, could be citizens. But that was an aberration. And then this 14th Amendment post-Civil War work by amending the Constitution restored the common law. So it's really almost an unbroken tradition with that really clear aberration with Dred Scott. And the court said, look, everything here points in the same direction. We have the text of the 14th Amendment. If that's what you focus on, it's unusually clear and means what it says. That language I read earlier, all persons born in the US and subject to the jurisdiction thereof are citizens. The court said, look, the legislative history of the 14th Amendment is unusually clear. We have actually texts and statements of legislators from the time of the amendment saying exactly what they meant, and that they meant this to confer citizenship on everyone born on our soil. And we also have a now over 100-year-old precedent from the Supreme Court, an 1898 decision called Wong Kim Ark, that again points in the same direction. This was a case about someone born in San Francisco to Chinese parents who at the time were not even eligible for naturalization. And he was denied re-entry to the US on an argument that he wasn't a citizen. The Supreme Court said, no, he was born on US soil, and under the 14th Amendment, he is a citizen. And there's only really narrow exceptions to that basic principle of birthright citizenship. So that was the constitutional holding. There was a separate 6-3 majority on a separate issue of whether the executive order violates the immigration statute that has existed since 1940. And Justice Kavanaugh is the reason there were two different numbers there. He was the judge who said, the justice who said he agrees that this law violates the immigration statute, but he went out of his way to say he doesn't think that it violates the Constitution. And so that's really concerning. He basically said, look, the immigration statute is, it is a bar to the executive order, but if it were changed, if Congress were to take action, that could change. And so right now, his vote is that difference between and why there was only a 5-4 decision on the really big constitutional issue.
It was a strange experience, I think, unusual for us as ACLU lawyers, that everybody seemed sure that we were going to win, which my, Yiddish grandmother would have been like, don't Kanahara. Scholars, newspapers, everybody says we're going to win. And it turned out we did win. Was this surprising to you, Carol, the way this case turned out?
Yeah, I mean, I think it was, in that it was so close. It was way closer than it should have been. It was way closer than I think even a lot of close court watchers thought it would be. Everyone coming out of it, as you said, thought it would be, maybe 8-1, maybe 7-2, maybe 6-3 on the constitutional issue. The fact that it was this unbelievably razor-thin margin of 5-4 on the basic constitutional principle I think is really shocking. This is a straightforward issue of constitutional law. In some ways, as I said, that it doesn't get, more clear than this in terms of the language, in terms of the legislative history. And we here saw 4 justices of the Supreme Court basically adopting a theory that was on the complete fringes of the legal communities and the court system just 2 or 3 years ago. So this is, gone from what was essentially laughed at in kind of corners of the room a few years ago to being adopted by almost half of the Supreme Court. And also, I think really surprising was that the arguments that we saw 4 justices adopting were exactly the arguments that were made and rejected by Wong Kim Ark's court in 1898. So we have a court that is really perilously close to adopting theories that were rejected by the same court in the late 1890s that issued the Plessy versus Ferguson separate but equal decision. So I think we're not in a great place when that happens. So yeah, I think I was really surprised by how this decision actually came out.
Are we celebrating nonetheless? I mean, there's certainly some very concerning language in especially the dissent opinions. Um, I don't know. Is there how are we how are we supposed to feel about this?
Great question. Yeah, I would love to tell people exactly how to feel. No, I think, you know, I mean, I think on the one hand, like huge sigh of relief for the moment. Birthright citizenship is still the law of the land. So that is something. And it took incredible work to get there by many people and
Yes.
many brave plaintiffs who stood up for the rights of others in this case. But it is very disturbing that we saw a court adopting these principles and the dissents especially. So I just kind of want to call out especially some of the comments, some of the remarks by Justice Jackson, who wrote a concurrence. And she wrote with the majority. She called out in particular the Justice Thomas dissent. And I want to just, you know, give a few of the flavor of what she called out for that dissent, because it really is so important, I think, in thinking about this case. She explained that Justice Thomas's telling elides the entire point of the second founding. The Reconstruction Amendments were an anti-caste, anti-subordination reset for the nation, not a mere spot treatment for the dark stain of slavery. And she really pointed out that the dissent from Justice Thomas and others really adopted a revisionist history. It is not doing serious history, and it is reinventing and making a totally different narrative that pits against each other, pits Black Americans against immigrants. When in fact, as Justice Jackson explains, the drafters of the 14th Amendment understood their fates are all linked. The fates of Black Americans, of immigrants, of all of the people making up our multiracial democracy are linked. And instead, the dissents tell this very dark story of sort of it's a zero-sum game. And by giving rights to some, we have to take rights away from others. So I'll stop there, Zach, and turn it over to you to talk a little bit about voting rights.
Yeah, I'm going to talk a little bit the next case, Louisiana versus Calais, although here we live in Maine, so it's very hard for me not to say Louisiana versus Calais. I'll do my best. Those of you who have watched, Carol and I do these updates over the years at the end of the Supreme Court term, or if you just followed the Supreme Court on your own, you know that there's often competition for what is the worst decision of the term from the Supreme Court. I would nominate Louisiana versus Calais as the worst decision of the term that's just finished. It's a case about the Voting Rights Act. It's an ACLU case that we brought along with our colleagues at the LDF, the Legal Defense Fund. And it is, really, just even thinking about it is really, it's painful. Louisiana versus Calais was a case where the Supreme Court told Louisiana that it needed to redraw its congressional voting districts. That's the maps that decide which people are represented by which of Louisiana's 6 representatives in Congress. Louisiana is about 30% Black, and the disputed map that was at issue would have created 2 majority Black districts instead of 1. That was the issue, sort of what it came down to, what the maps were that were in dispute. And the court said that groups who want to challenge voting districts as violating the Voting Rights Act need to show that these original districts were drawn intentionally for the purpose of affording minority voters less opportunity because of their race. So you could be forgiven for thinking that's not that big a deal, right? There's only 6 representatives from Louisiana out of 435 members of Congress. Every state redraws its legislative maps every 10 years to accommodate changes in the census. So I'm going to quickly tell you why this was such a big deal. The first thing to know about Louisiana versus Calais is it involves the Voting Rights Act of 1965. I think it's the most important law that Congress passed to end Jim Crow. Carol was just talking about the sort of post-Reconstruction civil rights amendments and the civil rights laws. This was the civil rights 100 years later when we still hadn't ended segregation in this country. The Civil Rights Act of 1964 tried to desegregate public accommodations and access to education. But in a democracy, groups only have the ability to protect themselves when they can build political power commensurate with their size. And there were laws throughout the South and throughout the country that prevented Black people from building political power. And the Voting Rights Act was supposed to fix that. Um, and one of the important ways that these states divided up Black political power was through voting districts, through gerrymandering and drawing voting districts that would prevent them from, ever having majority representation or having majority, representation that's consistent with the population. The Voting Rights Act was supposed to make that unlawful, illegal. Um, the second thing to know about Louisiana versus Calais is that this Supreme Court, the Roberts Court, has been at war against the Voting Rights Act for 20 years. They've made parts of it difficult or impossible to enforce. They've said other parts of it are unconstitutional under the 14th Amendment. To put that another way, the Supreme Court has said that the statute designed to end Jim Crow violates the constitutional provision designed to end slavery. The Supreme Court did not technically, in this case, say that Section 2 of the Voting Rights Act was unconstitutional. They'd done that a few years ago for Section 4 of the Voting Rights Act and Section 5 of the Voting Rights Act in a case called Shelby County versus Holder. But they did make it extremely difficult for anyone, including the ACLU and the NAACP, to actually enforce Section 2.
So, Zach, I remember, I think, as you said, like a little over 10 years ago when we saw the Shelby County case, and my memory is there that the court said, okay, well, we're getting rid of Section 5, this pre-clearance for changes to voting rights laws, but don't worry about it because we still have Section 2. That's really a core provision of the Voting Rights Act, So given that, were you surprised by now them turning around and getting rid of essentially Section 2?
Yeah, unfortunately, I was not surprised, right? This has been something that this court, particularly Chief Justice Roberts, has been on a decades-long mission about. I mentioned Shelby County versus Holder, which eliminated the special rules provision in the Voting Rights Act, which is called preclearance. And that preclearance applied to states with a particular documented history of racial bias in election administration. So the kind of states where you need to be worried. And the Supreme Court said that was, insulted the dignity of those states. So they got rid of that. Then there was a case called Rucho versus Common Cause in 2018, which really opened the door for the Calais decision. In Rucho, the court said that there's no way to challenge partisan gerrymandering. It didn't say that partisan gerrymandering was okay. It just said that nobody can ever challenge it in court. And courts should avoid judging how partisan gerrymandering plays into the drawing of districts. And it gave states a tool to, avoid the appearance of racial gerrymandering. They could just say, we're not trying to protect white voters, we're trying to protect Republican voters. And the court has essentially said that's okay. And then there was a case in 2021 called Brnovich versus Democratic National Committee, which made it much harder for voters to bring challenges against any individual practice under the Voting Rights Act. So this law that played such an important role in our history is really on its last legs, and it's something that really should concern all of us. There are proposals in Congress to revive the Voting Rights Act, to pass the John Lewis Act in memory of Representative Lewis. Those are not going anywhere fast, but the energy is still there, I think, for a lot of people who recognize that voting is so central to our democracy. Do you want to talk about the TPS cases, the termination cases?
Yeah, so I'm gonna talk about a few different immigration cases. I'm sort of on the immigration beat, and there are, I think, unfortunately, the Supreme Court has been taking up a lot of immigration cases, which usually is not good news for the rights of immigrants. And so I am going to talk about several different cases. They involve different issues, but they really all involve common themes for immigrants' rights. And I would say the overall theme is we are seeing a court that is really aggressively kind of taking power for itself to redefine the rules of what it means, who is entitled to be considered American in its view, and really trying to radically define ways that people can have lawful immigration status. So I'll primarily talk about the TPS cases. This is the temporary protected status program for immigrants. And it's two related cases. Mullen versus Doe is the primary case. So what is TPS? So TPS is a program that was created by Congress back under the first Bush one. And it provides people with temporary lawful status whenever they are fleeing from specific countries because of armed conflict or a natural disaster, like the earthquake in Haiti, or other, quote, extraordinary circumstances. So really narrow, defined conditions, emergency conditions in specific countries. TPS, as the name says, is a temporary status, but it can be extended by Congress when the conditions on the ground require that. And there are really strict provisions in the law for exactly how TPS can be terminated by the government. So before termination of TPS status for a given country, there needs to be consultation by the executive with the State Department about, what are the current conditions in that country. There needs to be at least a 60-day public notice that the termination is coming. And if there isn't that notice, then automatically the status is extended for 6 months from that date. The Trump administration took a radically different tack and basically issued a frontal attack on the entire TPS system. So Trump issued an executive order directing the Department of Homeland Security to limit the TPS program. And DHS has abided by that order and has now terminated TPS status for 13 different countries, usually with no reasoning and no discussion about what are the actual conditions in those countries. The court granted review in two cases. One was about Syrian TPS programs, and one was about Haiti TPS programs. And so the case that our ACLU Northern California affiliate handled, along with some partner organizations, was specifically about Syrian TPS. And so there, Trump ended TPS for Syria very abruptly last year, even though the State Department had found there was still an armed crisis. And even though the DHS Secretary Noem, made that decision unilaterally with no process at all. Syrian plaintiffs, a group of 7 brave plaintiffs, challenged that process, or really the lack of process by which DHS terminated the TPS status for that entire group of what was essentially 7,000 Syrians living in the United States. And they said, look, the government has discretion to terminate a TPS program, but it has to follow the really clear process laid out in the law. The government argued, no, actually courts have no ability to review an executive branch's decision to terminate TPS. It's basically completely insulated from judicial oversight. The plaintiffs, so the Syrian plaintiffs, they won in the district court. But then before there was any trial or fact-finding, the Trump administration essentially asked the Supreme Court to jump in at a really early stage, very similar to what actually it did in the Barber case. And so the Supreme Court agreed and took it up on this very fast basis.
So it sounds like there are at least 2 issues, right? There's due process, which is supposed to protect sort of fair operation in government. The government's supposed to follow the rules and do things in an orderly manner, and it's predictable. And then there's the equal protection piece, right? The government's not supposed to discriminate against particular groups on the basis of their race or their appearance or their ethnicity or where they're from. How did it go with those arguments at the court?
Yeah, that's exactly right. It's those 2 big issues. It went badly for both of those arguments. So the court upheld the administration's, basically unreasoned termination of the TPS program, both for Haiti and for Syria. It was a 6-3 decision. And their reasoning, they essentially agreed with everything the government argued. They said that the TPS statute, even though it has all these processes that are, very clear and black and white in the law, they said that the TPS statute bars any court review of whether DHS is actually following those processes. And so even a blatantly illegal process, like what happened here we had, one short email sent to the State Department by Secretary Noem, that was it. Even that just can't be reviewed by courts. And so it essentially makes all of those parts of the law about the process that needs to be required, it makes it meaningless because courts are powerless to enforce it. And then on the really important second issue, Zach mentioned that there's a constitutional question here. Does the termination of the TPS program for these two countries violate equal protection because it is overtly racial. And here the court said, well, even though we had pretty clear racially based statements by the president and by the DHS secretary, those were comments like, for example, Haitians are eating your cats and dogs. They are poisoning the blood of our country. Just hateful, horrible statements by the people in power here. But the majority in the Supreme Court said, you know what, that's not overtly racial enough. Instead, that's just expressing policy views. There could be race neutral justification. So it essentially, excused away these really, really obviously racial statements. And I think essentially imposed what is an almost impossibly high standard for making out an equal protection claim. It's sort of, if these kinds of overtly racial statements aren't enough, it's hard to imagine what is.
So it's, as lawyers, we often focus on the legal issues, the constitutional issues, the doctrinal principles at stake. But this case had real practical impact, didn't it?
Yeah, it did. So just for the people involved in the case, as I said, there were 7,000 Syrian TPS holders represented by the ACLU affiliate. But there's actually 350,000 people from Haiti and Syria combined, and over 1.3 million TPS holders in our country at the moment from 13 different countries. All of those people now could immediately lose their lawful status. They could lose their work status. They could be arrested and deported. And many of these people have been here for years. Some have been here for decades. And so they're people who are deeply integrated into communities. They have families. They have jobs. Many of them are doing healthcare and long-term care. 30% of the Haitians working here are doing work in nursing homes and senior care. So they're just doing incredibly important work and are playing incredibly important roles in our communities. And all of those people now could lose their status.
You want to talk a little bit about the other immigration case, or is it getting just too depressing?
I think we can take it, and I feel like it's important to know what's happening. So I'll just very briefly touch on another big case was called El Ultralado, and this is a case where, again, the court is really putting limits on what it considers to be who it considers could be considered American. So this was issued the same day as the TPS case. It was just an incredibly devastating day. And this case is really a frontal assault on the asylum process. So our asylum process, like the asylum process in many other countries, it was really constructed in the wake of World War II and the Holocaust. It is a way to ensure that when people are fleeing from persecution or torture, they can seek safety at another country's border. El Ultralado, the Supreme Court case that we are talking about here, the court essentially held that people only have a right to seek asylum in the US if they successfully cross our border and are inside the United States. They don't have a right to seek asylum if they present themselves to a government official at the border and the government official turns them away. So that essentially makes the asylum program meaningless if government officials can just turn people away and say, well, you aren't even covered by our asylum program. So I think, this, and there was also a terrible decision about green card holders. There's just an undercurrent in all of these cases that even though these people are all following the rules, they are all people who had lawful status under our asylum programs, our TPS programs. They are doing everything right, and yet the administration and the court are together working not just to deport people on a mass basis who are here unlawfully, but even to erase whole categories of lawful status. So that's just a whole nother effort to narrow what it means to be here and part of our citizenry.
Thanks. I'm going to talk a little bit about Chatry versus United States next, which is a case about the Fourth Amendment, about searches and seizures. So you just heard a lot of bad news. Here's the thing to remember at the Supreme Court. It's never all bad news. Obviously, Barbara was the most important case that we won this year, this decade, maybe this century. Chatry was also a hugely important case. And it's kind of amazing to me still that it came out the way that we were hoping. Um, this is a case that involves, I'll bet, many of you who are watching. I don't know how many of you own a cell phone, but this is a case about cell phones and location information related to our use of cell phones. It, in, it concerned the constitutionality of something called a geofence warrant. If you have your cell phone on now, you have your location settings so you can find directions to things. It's keeping track, those apps are keeping track of the location of your cell phone. So a geofence warrant is a warrant that the government gives in a criminal case to a tech company. In this case, it was Google, and says, we know that your servers are in contact with cell phones all over the world at all times, and we want the identification of all the cell phone users who were in a particular place at a particular time. So in this case, they asked Google for all the cell phone users who are within 150 meters of a particular location on a particular day. And that circle included apartment buildings, it included a church, it included several businesses. And one person who was in that circle may have committed a crime, but hundreds of people, maybe even thousands of people who were in that circle hadn't done anything wrong. They weren't suspected of having done anything wrong. So this is sometimes called like a dragnet search, but it's kind of an insult to dragnets, right? It's like if a fisherman went out with a dragnet and caught one tuna and 800 dolphins. Well, that's the kind of search that we're talking about here. So
Um,
the court, yeah,
Yeah,
go on, Carol.
I love this case because it's about something that is so important and so much a part of our all of our daily lives. But I think something, I mean, I don't think I even knew the term geofencing until I read
Yeah.
this case. It's something that I think kind of reveals a constant tracking we weren't even aware of, and so it's just unbelievably important. And so what did the court say in this case?
So it was a 6-3 decision. Justice Kagan authored it for the court. And she said that these geofence warrants, um, trigger a Fourth Amendment scrutiny. The Fourth Amendment is the part of the Constitution that prohibits unreasonable searches and seizures. And what the court said for years, what makes a search reasonable is that it's based on some individual suspicion of wrongdoing, right? You think somebody's committed a crime or you have evidence that they're going to commit a crime, then you can do a search. Then you can look through their papers, you can look through their house. But here, the government searched the location of hundreds of people, the information about hundreds of people who had done nothing wrong, and the government didn't have any reason to think that they'd done anything wrong. They just happened to be in a particular location. The fact that they may live or work or pray in a particular place near where a crime took place doesn't trigger suspicion for Fourth Amendment purposes, reasonable suspicion for Fourth Amendment purposes. And so it was sort of a 6-3 decision. Justice Gorsuch agreed with the conclusion, but he wrote his own separate decision.
So this is, obviously important in the sort of concrete terms of what they can do for the geofencing, realm. But what are the sort of broader implications of this case?
Yeah, one of the biggest implications of it, something that's called third party doctrine. The Supreme Court in the 1970s came up with this idea that when we have information that we voluntarily turn over to a third party, like a company, it was a bank or a phone company, that we give up any kind of Fourth Amendment protection for that information, right? We've turned it over to a third party. The government can go to that third party and get the information, and it doesn't, we can't complain about it because we turned it over. And this came up like when the information at issue was the number, like the phone number that you dialed on the phone. Remember phones? Um, it was, a case called Smith versus Maryland from 1979. Nobody at the time had the kind of information that these tech companies have about all of our movement, all of our associations. And the Supreme Court, for about the last 12 years, has been sort of gradually chipping away at this third party doctrine, saying it doesn't really apply, it doesn't really make sense in this new tech world that we live in. And this, I feel like, is kind of the end of it. Like, we're not going to hear about third party doctrine anymore after Chattree. And that's a good thing from constitutional perspective.
Yeah. It's
Do you want
great.
to talk quickly about the trans athletes cases?
Yeah, I will touch briefly on these. So this is two cases. One is called BPJ and the other is called Little versus Hecox. But both are about the same issue. They're essentially about trans athletes who are participating in sports. And this is another case that was litigated and brought by the ACLU. So I'll focus on BPJ. That was the central case. This was about a middle school runner who challenged a West Virginia law from 2021 that banned trans children from playing sports on the team that matched their gender identity. And it challenged that under, Title IX, the statute, and under the Equal Protection Clause. Both the lower court and the appellate court struck down the ban, agreed with the ACLU's position, and essentially said that these laws violate the statute and the Constitution. The Supreme Court went a different direction, and in a 6-3 decision said, no, actually, both Title IX and the Equal Protection Law permit these kinds of state mandates. The court, essentially, in terms of its reasoning, I think its reasoning was basically just that there's a unique context for sports. And it talked a lot about how sports are special and unique, and talked a lot about, quote, inherent physical differences between girls assigned the sex of female at birth and boys assigned the sex of male at birth. So, supposed inherent physical differences and the uniqueness of sports were really behind the court's decision. The good news, if there is a sort of silver lining here, is that all the court decided, it was a relatively narrow decision. It just said that the federal law allows states to make these kinds of laws, mandating that kids play on the team that matches their biological sex at birth. It did not say that states have to do that. And so what does that mean for us in Maine? It doesn't affect states like Maine that already have broad state law protections for gender identity discrimination. So our state Maine Human Rights Act, which continues to be in full force, it protects trans students from discrimination really explicitly and has for years now. And so that law mandates that schools allow students to play on the team that matches their gender identity. But this decision, although it doesn't take away our state law protections, it makes those state law protections all the more crucial because we no longer have sort of a federal backstop. We don't have a backup plan. And it also means that this is no longer a universal kind of constitutional principle all over our country. Instead, the protections that trans kids have depend on where they live, on sort of the accident of where they happen to be living. And it depends on often changing state laws.
I think probably we should stop here and move to the question and answers. I know there's a number of questions that people have posed. I don't know, Aaron. Thank you for rejoining us. And do you want to moderate that some?
Yeah, and before we get to that, I'll just say feel free to keep adding questions now using the Q&A tool. But we have some questions there, and I have some questions. One that is in the Q&A asks whether so this is going back to Calais and to the Voting Rights Act that you talked about earlier. Even if we could pass the John Lewis Voting Rights, and then there's another A Act in the title of the John Lewis bill, wouldn't SCOTUS just declare it unconstitutional? Should we assume that the legislative remedies to some of this are non-starters, or are there ways to write them that are more insulated from that result?
We should not assume that. I think it's good to be cautious, but that caution should lead us to really carefully parse the precedents at issue, what the Supreme Court has said the constitutional infirmities are. First, the constitutional infirmities would be exercise of the congressional power, but then any of the defects that might infringe upon principles of federalism are, doing our work really carefully guarantees that the Supreme Court's not going to make up new rules and strike things down? Absolutely not. But we can't, just sit back and let them just say that voting is, that we're going back to having voting be the way that it was um, in the Jim Crow era. That's just not acceptable. It's going to be difficult. It's going to take a lot of work, but I think, on this issue and on many issues where that really demand a federal legislative response, we need to continue pushing our elected officials to do better.
Sure. Going back to Trump v. Barbara, the birthright citizenship case that we won, um, I was just wondering whether it seems like very plain language for the Constitution, but I just wondered if one of you actually could illustrate what subject to the jurisdiction of means, and was that the linchpin for those who wanted to say that it isn't as plain as it really seems to be?
Yeah, so what was, clear from even the legislative debates when the amendment was passed and then was made really clear in that 1890s Supreme Court decision was that subject to the jurisdiction of the United States means essentially that the person doesn't have some clear allegiance to a foreign power. So the examples that the Supreme Court gave in the 1890s decision was a child who's born to a foreign diplomat while they're, temporarily here in the US, or a child of an invading army. Those are the kinds of examples of someone who has a clear, jurisdiction. They are subject to that foreign power's jurisdiction, and so they are not subject to the jurisdiction of the United States. But everyone else is subject to the jurisdiction of the United States because they live here. And they don't need to owe some kind of other special loyalty. We're not a country that has loyalty tests. And they certainly don't have, subject to the jurisdiction thereof, certainly doesn't impose a requirement about what immigration status your parents have. So that's essentially what the court said over 100 years ago. Again, this is not a progressive court that said that, far from it. And that is what the law and has been for the next 130 years since then.
Great, thank you. So we have a question about the Bivens Act, which might require explaining what the Bivens Act is, but whether we could pass a Maine Universal Constitutional Remedies Act. And so I think, again, I start with what Bivens is and why this might be related to some of these issues.
Sure. Bivens is the name is a legal doctrine that comes out of a case from the 1970s that kind of fills a gap of pursuing federal officers for violations of the federal Constitution. You wouldn't think that would be like you would need a special doctrine for that. Obviously, federal officers have to follow the federal Constitution, but it's very hard to go into court and do that. So this case called Bivens was a way that the Supreme Court opened up a channel to sue like an FBI agent who violates your rights. But since then, the Supreme Court has cut back on Bivens to make it harder and harder, and now nearly impossible in many cases, to use Bivens to sue federal officers. This is obviously very important. We have federal officers here in Maine committing all sorts of acts violating people's rights, and it sure would be important to be able to sue them and hold them accountable. Luckily, the Maine Civil Rights Act actually does provide a mechanism for holding federal officers accountable. Carol, I don't know if you want to talk a little bit about our case on that subject.
Yeah. So our Maine Civil Rights Act, and we're one of just a few states that already have very broad language. It's not limited just to state officers who violate the Constitution. It's for anyone who violates the Constitution can be held responsible under our Maine Civil Rights Act. And so we actually have a case about this right now that we filed a few months ago on behalf of someone who was unlawfully abducted. He has lawful status here. He was abducted on the streets by ICE agents. They bashed his window, they seized him and shackled him, completely lawless activity. And we've sued in federal court under the Maine Civil Rights Act and are making exactly this argument that our law already provides for a remedy against federal officers when they violate the federal Constitution, which again, we shouldn't need to even have separate laws that say that. It should be so obvious. If nothing else, federal officers should not be able to violate the federal Constitution. But we do need to have that, and we I think have a really strong Maine law that we're hopeful the court will agree can be used as it has been actually since the founding of our country. These state law mechanisms were traditionally the way that federal officers were always held accountable. That was one of the primary sort of evils that our founders were trying to prevent, was abuses of federal power.
Great. We have time for just maybe one and a half more. Um, and so we do have a question about court reform. So do we, would changes to the shape of the court, um, impact what we see on these? Is that something that in the past has, it has certainly been done in the past, right? The shape of the court has not always been what it is right now. It hasn't always been nine justices. But um, yeah, does something like the decision we saw in Barbara and how close it was say anything to you about the shape or size of the court or how it works?
Yeah, it's a really tough question, right? Because we just don't know. Um, if there were more justices, would there be more justices appointed by this president who think that the citizenship clause of the 14th Amendment doesn't mean what it says it means? That case could come out, 9-6 or whatever, based on however many justices you add. Um, there's always the hope, right? If you the people that the arc of the moral universe bends towards justice, and so if we change the Supreme Court, we're going to improve our outcomes. The part of that phrase we sometimes like to forget is that the arc of the moral universe is long. I don't know whether so in the short term whether changing the composition of the court is going to change the outcome. I think demanding of our elected officials that they only, confirm justices who have a real respect for precedent and a respect for the Constitution might go a long way. But that's been a really hard challenge. I think it's something hopefully that all voters care about.
Great. And so one that I think is good to end on is when will we find out what's in the next term? So there was a question about whether Times v. Sullivan might be overturned. We could have the very briefest description of what Times v. Sullivan is. But what's coming up next? Is it too soon to say? Are they all off? Some of them might be at salmon fishing camps, and others might be relaxing in other ways on their break from the term. Yeah, next term. What's next?
We
Yeah.
know a little bit about it. Yeah, go on, Carol.
Oh no, go ahead, Zach.
I should say we know a few cases have already been granted. Some of them are quite troubling. There's a case about religious schools, another case about religious schools. Those of you remember Carson versus Macon, which was a Maine case about religious schools. There's yet another case about whether religious schools have to follow generally applicable non-discrimination laws. Um, Usually the big moment when the court adds a lot of cases is right before it starts its new term, the October term begins the first Monday in October. So the end of September, we'll get a whole number, a huge list of cases that are now going to be heard over the course of the year. But there are already some that are concerning, and I'm sure there'll be more.
Yeah, and I'll just say, yeah, there's a couple of different immigration related cases that they've already said they want to review. Again, not probably good news. They're continuing to take big cases. I will say this term, a lot of the cases that ended up being huge blockbuster cases, including Barbara, that wasn't granted until way late, and it was on this wild expedited basis. So, even though often we learn in October what's going to be, in an orderly fashion for the October term. That has changed because the court is just operating in this much more sort of, unusual, expedited way. And the other thing I would just flag is, yeah, that again, yeah, they'll be off, maybe fishing or taking trips, but I expect the Supreme Court to be continuing to issue these shadow docket decisions. And so, yeah, keep an eye out because often, even though it's only a page, a shadow docket decision can just radically change the rights for, hundreds of thousands of people sometime with just a few words. So keep an eye out. Those decisions will probably keep coming out, in the next couple months before the term even starts.
Great. All right. So thank you, Carol and Zach and Molly, who joined us at the top. I would encourage you all to visit aclumaine.org and especially aclumaine.org/ice out for the latest on the ice out of Maine laws. You can visit our site for that Know Your Rights information and keep an eye out for news on new terms, new legislation, new cases, and ways you can engage with us. So thanks again, and I hope everyone has a good night tonight.